and whether or not it's lawful under Chevron being repealed. The EPA's Clean Power Plan 2.0 is the perfect example, where there's probably a strong likelihood that that might go down in court, as Clean Power Plan 1.0 did. But in the meantime, the entire utility industry is essentially subject to these requirements and has to retool to meet them. So sometimes these rules can have the effect that they wanted, even if they ultimately are found to be unlawful. All right, ladies and gentlemen, welcome back to another episode of PowerGab, your go-to show for all things energy and environmental policy in the state of Colorado. I'm co-host Jake Fogleman, joined by my co-host Amy Cooke remotely today. And we actually have a guest in studio with us, I think for the first time that we've done. Before I introduce our guest today, just to tell you a little bit about what this show topic is going to be. You may have heard a few months back a lot of Chicken Little predictions about the end of the legal world as we know it, because the Supreme Court overturned a certain legal doctrine. I won't get too far into it until we let our guest take over, but that's what we want to talk about today, is sort of the effects of that being overturned, what that might mean for Colorado, and what that really looks like going forward for the entire regulatory state. So to tell us more about that, we have the Independence Institute's very own Senior Fellow in Constitutional Jurisprudence, Rob Natelson. Rob is also a former constitutional law professor at the University of Montana, and you've been cited by the Supreme Court a time or two, I believe. Isn't that right, Rob?
Yeah, a time or two.
Yeah. So thank you, Rob, for joining us today.
Well, thank you, Jake. Thank you, Amy.
Before, just to kick us off, can you tell us what exactly the Supreme Court did in the Loper-Bright case and what the Chevron Doctrine is?
Let's do some background, if we can. The Supreme Court in the 20th century created certain fictions to allow the federal government to exceed the powers that the Constitution actually gives it. During the time that the Constitution was being debated, one of the most common representations regarding it is that the control over the economy, control over land use, most of that would be reserved to the states, and that the federal government would have only a few peripheral, although important functions. But in the 20th century, this was changed. It was changed in four ways. One was that the court ruled that the power to regulate interstate commerce, which is given to Congress, encompasses not just commerce as traditionally understood, but the entire economy. Small change, right? The second was that Congress could take its newfound power and devolve it, delegate it to administrative agencies. So even though Congress can pass laws on a lot of subjects, it's not actually bothered with the day-to-day task of keeping those laws up to date. We simply pass the job on to administrative agencies. Thirdly, the Supreme Court adopted a rule that anyone who argues in court that a particular federal law of this kind is unconstitutional bears the burden of proving it unconstitutional beyond a reasonable doubt. And the fourth prong of this is the Chevron Doctrine. And that is essentially the same kind of rule for administrative agencies. If someone wished to argue that an administrative regulation was beyond the power that Congress gave the agency, one had to prove that beyond a reasonable doubt. That if there was any way that the agency could justify this rule under the statute, even if it wasn't a particularly good argument, then the agency would win. The agency's determination of its own power would control. And that's why we call this Chevron deference, because this came in a 1984 case called the Chevron case. And by this rule, the Supreme Court deferred to the agency's determination of the scope of its own power. So the agency, in effect, became a judge in its own cause.
Right. It was essentially its own, like you said, own in-house judge of its own legislative powers, even though it's an executive agency. Yeah. So you can see the problem right there.
Now, the Supreme Court has been backing away from Chevron for some time, and had not actually applied the doctrine since 2016. But in this Loper-Bright versus Raimondo case, the court finally said enough is enough. Under the Administrative Procedures Act, which is the statute that governs administrative agencies, the power to judge whether an agency has power is not left to the agency. It's assigned to us, to the courts.
Right.
And so the court ruled that under the Administrative Procedures Act, Chevron is not law. It contradicts with the Administrative Procedures Act. In addition to that, Justice Thomas wrote a very interesting concurrence in which he pointed out that Chevron not only violates federal law, it also violates the Constitution, because under the Constitution, the power to adjudge cases is given to the judicial branch, not to the agencies that are part of the executive branch.
So in sum, Chevron is no more.
No more.
And sort of, Amy, do you want to ask questions about what that exactly means?
Yeah, so you wrote a column, Rob, and this is what intrigued both Jake and me, is that we look at energy and environmental policy from the standpoint of Colorado. We try to keep it Colorado-centric. So we'll touch on something at the federal level, but it's at the intersection of Colorado. And you made a compelling case in your column, which you can find in Complete Colorado, and we'll have in the show notes, that this helps, I love this, real Colorado. You actually call it real Colorado, which then assumes there is a faux Colorado or an unreal Colorado. And I would say that there are certainly some that have made policy in Colorado that should be unreal because it is clearly unrealistic. But what is the benefit to Colorado with Chevron? And what did you mean by real Colorado?
Well, real Colorado refers to what this state actually is. This is a Western state. And you would perhaps not know that if you never ventured outside of the Denver Boulder Metroplex. But this is a Western state, and like other Western states, its economy, its way of life, its culture centers largely around the land and using the land for various purposes: agriculture, ranching, energy production, and so forth. And the current group that controls the state tends to forget that. I mean, they assume that this is Massachusetts or something, and they've got no real sympathy or resonance with the rest of the state. It is the real Colorado, the part of Colorado that is a Western state, that is going to benefit disproportionately from the repeal of the Chevron Doctrine. And the reason for that is that some of the most aggressive federal agencies that have pushed their Chevron privileges to the limit have been agencies that regulate land use, mining, ranching, agriculture, the environment, and so forth. And I gave some examples of that. So the real Colorado will benefit disproportionately from the repeal of the Chevron Doctrine, because for the first time now in 40 years, people challenging federal regulations as exceeding congressional power will get an equal chance in court. It won't be a matter of, if there's any doubt at all, the decision goes to the agency.
So counties like the one where I live in Colorado, Weld County.
Yes.
This doesn't happen overnight either. So the lawsuits have to be brought, and there is a lot of, well, let's say 4 decades of deconstructing this. But you're saying that, for instance, Weld County, because it is uses the natural resources underneath, the surface land, right? Yeah. It uses its resources and develops it. That this is something that will help them in the future if lawsuits come up, or maybe the lawsuit to challenge some of the federal regulations. Also, what about the state regulations on the ability to utilize your land? That they often said, well, if we don't do it, the EPA is going to make us anyway.
Well, that argument is now largely gone. I mean, that's a very common argument among state officials and legislators who want to pass the buck. Well, if we don't do it, then the feds will do it for us, or they'll take away our money, or they'll do the regulation. That argument has been partially gutted by the fact that Chevron is gone. In the op-ed that you referred to, I actually gave one example, and there are more, of the ways in which the federal agencies have been pushing their Chevron powers to the limit. The example I used is a case called Sackett versus Environmental Protection Agency, where, and this actually involved an Idaho couple. An Idaho couple had land, there was no water on the land, but the EPA suddenly claimed the right to control their land by under the doctrine that navigable waters were involved. This particular couple owned land which was on a road. The road was 30 feet wide, and on the other side of the road, there was a ditch where water ran sometime, non-navigable. This ditch ran into a stream, also non-navigable. The stream ran into Priest Lake, which the EPA claimed was navigable. And so the EPA claimed the right to control this couple's land based upon the fact that they were 30 feet from a non-navigable ditch that ran into a non-navigable stream, which ran into a lake, which, by the way, wasn't really a lake that was used for commerce, but because tourists were sometimes there, the EPA called it navigable. Now, the Supreme Court struck down the EPA's pretensions in that case, even before abolishing the Chevron Doctrine. But that illustrates the way in which the federal agencies use the Chevron to expand their own power. Another great example was one where the Army Corps of Engineers claimed that a pool of water inside a deserted quarry was a navigable waterway because migratory birds sometimes parked themselves there. And so at least people challenging this sort of thing will not face the uphill fight that they faced. And by the way, most people don't challenge it because the EPA and other administrative agencies come in and they say, you can challenge if you like, but if you lose this case, as you probably will, it'll cost you $40,000 a day, that sort of thing. So those days, if they're not entirely gone, at least maybe passing into history.
Yeah, sorry, Amy, I love the fact that you use those examples in your op-ed because, as I sort of teased at the beginning of the show, after Chevron was overturned, you heard lots of doomsday prophesying about, oh, this is the death of agency expertise and what Congress is supposed to be the experts on everything. How can they possibly? Well, it's good to know, note the real world implications of that line of thinking, delegating all of your expertise to this unaccountable body, what that actually means for real people, and sometimes absurd examples of navigable waters.
Yeah, I mean, you would like Chevron if you're in favor of oligarchy, okay? Yeah. All that Chevron says is if you're going to engage in this kind of intrusion in people's lives, you at least ought to have a congressional law to that purpose, a law passed democratically, right, not according to the oligarchy of the deep state.
Right. Sorry, Amy, I know I cut you off before.
That was the question I wanted to ask. Doesn't this mean now that Congress is going to have to do its job? And I'll bring up the one that drives me crazy, and that is the determination by the EPA that CO2 is a pollutant. Now, if Congress wants the EPA to regulate CO2, it should say so, and it should be explicit in how it should be regulated. Instead, what you have is the Clean Air Act, where EPA assumes it has the authority. Congress doesn't do anything. We have Chevron deference. Yeah, go ahead, regulate CO2. Now, all energy policy is for, and environmental policy is forced through the myopic lens of CO2 emissions. Occasionally, they'll expand it to greenhouse gas emission, but there's a reason why we call it net zero or carbon neutrality. I mean, it is CO2, and it is through that very narrow lens. And Congress has never said, EPA, go out and regulate CO2. And in fact, get aggressive about it.
Yeah, Amy, it's a really excellent point because you say what you want about Congress. When you've got measures before Congress, people from all walks of life can be heard. You don't have that myopic or single-minded attention that's given to an issue by bureaucrats who are immersed in the DC power structure and in their own subject matter. You've got to hear from people. If you want to pass something through Congress, you've got to hear from people from all walks of life, interest groups of all kinds, and you get a much better perspective. And that's one of the things I think that the justices had in mind when they overturned Chevron. This is supposed to be a democratic republic, right? And we're supposed to hear all points of view before we adopt legislation like this. It should not be a matter of oligarchical control.
Yeah. This raises a couple questions I have for you, Rob, in the aftermath of Chevron going away. I think you touched on it briefly. So Chevron going away doesn't automatically mean that the last 40 years of jurisprudence on these regulations suddenly go up in smoke, right?
That's right.
It's forward-looking, future-looking. There would have to be future lawsuits to challenge Chevron, if I'm correct, right?
Yeah, the court was very clear that we're not going to overturn all the cases we've decided based upon Chevron. However, one thing I think we should say for our viewers is that the Loper-Bright case, the case that overturned Chevron, is not the only example in this Supreme Court term where the Supreme Court trimmed back the power of the administrative agencies. We saw the bump stock case in which the Bureau of Alcohol, Tobacco, and Firearms and Explosives version of what a bump stock was overturned. Now, what was interesting about that case is the ATF formally took the position that bump stocks did not convert a weapon into a prohibited machine gun, and then they changed their view. One of the points that Justice Gorsuch made in the case overturning Chevron is that with Chevron, not only did you have the bureaucratic agency making the final determination, but the bureaucratic agency often changed its mind, and whenever it changed its mind, the new law is what applied.
Right.
So we're going to have additional stability. In addition, the court ruled in a very important case involving the Security and Exchange Commission that if you want to impose those massive $40,000 a day fines on people, in most cases, you've got to give them a trial by jury. You can't say to somebody who challenges the fine, okay, we're going to give you another administrative hearing within our agency as to whether the fine is appropriate. People are entitled under the Sixth Amendment, under the Eighth Amendment, to a trial by jury. And then yet in another case called the Corner Post case, the court said, the 6-year statute of limitations on applying a regulation doesn't necessarily begin when the regulation comes in. If you are a business which started up, let's say a few years after the regulation was adopted, you've got 6 years from the time you started your business. And so you've got this package of cases that the court adopted this year, which should begin, I think, to trim back at least some of the worst excesses of the administrative state.
Yeah, I think it's fair to say that the federal bureaucracy certainly took it on the chin a little bit.
They did. Now, but remember, though, they've still got those 3 other prongs that I mentioned earlier. Sure. They still got this ridiculously over-expansive interpretation of the Commerce Clause. It still requires proof beyond a reasonable doubt to declare an economic law unconstitutional. And you still have a massive scope for delegation to administrative agencies.
Right.
This is only a trimming around the edges. It's not a frontal attack.
And that brings up another realm that's particularly relevant here in Colorado is there's also the realm of state administrative law
Yes.
and state deference and delegation, particularly in Colorado, because oftentimes a lot of these regulations are either duplicated, whatever the EPA does is duplicated at the state level, or sometimes Colorado's at the forefront.
We should make clear, Jake, that the repeal of the Chevron Doctrine applies to federal agencies. Yeah. It does not apply to state agencies.
Yes.
It is true that over time, very often state agencies and procedures tend to follow the federal precedents. So we may very well have challenges to agency deference here in Colorado, but I don't think, given our current court system, that I would be too optimistic about such challenges.
Yeah, I think that's an important point to make because a lot of this stuff happens at the state level as well, particularly on this climate and environmental policy that we talk about so often on this show. And one other thing I want to hit on that maybe is a little bit of a Debbie Downer on folks that are excited by Chevron being repealed is that we'll link to this in the show notes as well. Our friend Travis Fisher over at the Cato Institute did an article about this a while back about sort of hold your horses a little bit on getting too excited about Chevron because, to your point, the litigation challenging these rules often takes a long time. Yes. It goes through many levels of the court system. And in the meantime, businesses, industries reorient the way they do things, relying on that promulgated regulation, whether or not it's lawful under Chevron being repealed. The EPA's Clean Power Plan 2.0 is the perfect example, where there's probably a strong likelihood that might go down in court, as Clean Power Plan 1.0 did. But in the meantime, the entire utility industry is essentially subject to these requirements and has to retool to meet them. So sometimes these rules can have the effect that they wanted, even if they ultimately are found to be unlawful.
Yeah, and Jake, I think it's important to mention this point because this leads into a little lesson here. For all the squawking you hear about the Supreme Court allegedly having a 6-3 conservative majority or being a right-wing court, the fact is that this is a centrist court. And they do not, when they come up with changes, they tend not to push them too far. They tend to be very cautious. And like other changes that the court has made, this is an important incremental change in the right direction, but it's only an incremental change. It is not a fundamental or central change to the administrative state.
Yeah, that's an important point. Amy, did you have any further questions for Rob, or do you want to kick us off with our takeaways from this episode?
Yeah, but real quick, I will say this. It's not really a question as much as, Rob, you might be able to appreciate this as a former constitutional law professor. There are law schools around the country retooling their curriculum around regulatory law and administrative law. And
that happens after every Supreme Court term. And you have the mostly liberal law professors at least these days, going into dejection and saying things are going to hell in a handbasket. They're neither going to hell in a handbasket nor to heaven in a handbasket.
Well, it's one of my takeaways will be not only will it not go to either, it won't even go to either quickly.
Right.
So I'm excited that Chevron was overturned, obviously, but one of the takeaways is, for me, I'm encouraged that we can expand the debate, hopefully, around energy and environmental policy. Yes. That is more than just that myopic lens of EPA regulating CO2. That we can now talk about have a wider argument about these policies. So I'm optimistic about that. Maybe it's Pollyanna, but I'm optimistic about that one. I think my pessimism, though, is in state agencies in Colorado. I love the way you described real Colorado. Unfortunately, real Colorado is under the thumb of the Denver Boulder Metroplex, as you described it, that runs much of the state. And until voters throw that regime out, we'll see an expansion for sure in some states, others maybe at the federal level, hopefully, but Colorado has some house cleaning to do on this. And the last thing, this is going to take a long time. To that point, it took us 40 years to get here. We've got to unravel it. So in the meantime, get a generator, because not convinced your power is going to be reliable tomorrow just because Chevron is gone.
Sage advice as always, Amy. Rob, we want to thank you for joining us on this episode.
Thank you.
Listeners, if you enjoyed what we did here, feel free to check out our entire back catalog at iitv.org. We have new episodes every single week. If you want to suggest featured guests or show topics, you can send those over to info@powergab.org. We love to hear from you guys. You can also check us out on audio versions, wherever you get your audio podcasts, whether that's Spotify or Apple Podcasts. We're available there. But until next time, we'll see you.